Staying in Pretoria, the Senzo Meyiwa murder trial got underway again today, but the cross-examination of the first witness did not. There were other matters to deal with first. Counsel for accused number 5 says her client's constitutional rights have been infringed upon. Advocate Senzo Meyiwa says the state failed to disclose docket 375 to her before the trial began, and this denied the accused the right to a fair trial. Now, of course, you know there are 2 separate dockets detailing different versions of events of what could have happened at Kelly Khumalo's family home the night the football star was shot in 2014. 5 men are currently on trial, accused of entering the house and killing Meyiwa. Silindelo Masikane reports.
Docket 375 was introduced by the defense for accused 1 to 4 during cross-examination of the state's first witness. This docket alleges that those who were in the house have a case to answer to. Advocate Senzo Meyiwa for accused 5 is crying foul and made an application in terms of section 317 of the Criminal Procedure Act.
The content of evidence in docket Force Laura's case 37501-2019 ought to have been disclosed to the applicant before he pleaded. The applicant's constitutional right in terms of section 35(3) of the Constitution has been violated in that the applicant was not provided with sufficient detail of the charge before he pleaded. Number 8, as a result, the conduct of the respondent, the state, has rendered these proceedings not in accordance with the law. The furtherance of these proceedings is both unconstitutional and not in accordance with the law.
The state says the application is unnecessary and should be dismissed.
Make the submission that the application for a special entry is premature and ought to be dismissed, and we advance the following reasons. Firstly, and we will refer to the relevant case law in this regard. In paragraph 1.2.1, we say that special entries are a route to the appeal court and therefore presupposes that there must be a verdict of guilty. And we are making the submission that there hasn't been such a verdict in Kasu.
Lawyer for accused 1 to 4, Titi Tobane, also raised an issue regarding the state's position on docket 375. In an email, the NPA said a decision would be made on the docket after the conclusion of this trial. But the letter handed to the court says the NPA is still studying the docket.
Your Lordship, I'm very concerned, and I agree with the court that 375, the court has made the decision that it is irrelevant with regard to the proceedings of 636. However, if the court entertains the application that is pending of 375, based on 375 docket, it will make it relevant. And even this letter on the 26th of August 2022 then makes it relevant to the proceedings. The state is like playing chess games. They inform the court about this letter but doesn't hand it in. Whereas this letter that was given to us today is different from the one we received by email.
The trial resumes on Tuesday with a decision on Meyiwa's application and cross-examination of the state's first witness, Sergeant Thabo Mosia, expected to continue. Silindelo Masikane, Pretoria.